Hello, law students. This is Mrs. Politsky, and I have your continuation of your notes from Chapter 4, talking about crime. And we're going to take a look at Section 2, criminal procedure. So, rights and responsibilities. The major objective of the Constitution is to protect individuals from certain actions of the federal government. And it's better to give individuals too much liberty than to allow the government to have too much power. Rights when you're arrested, this kind of falls under the right to due process of law. When we start talking about constitutional amendments, we're talking about primarily the Fourth Amendment, Fifth Amendment. As far as Bill of Rights, those are really amendments that kind of deal with this. But it's our fundamental fairness in government actions. It requires procedures, fair procedures when we talk about during the investigation in a court. You have the right not to testify against yourself. You have the right of the accused to have a lawyer present. And to convict, evidence must be established beyond what is known as the reasonable doubt. 90% of the evidence must support a guilty verdict. Part of the rights of arrested is the reading of the Miranda warning or the Miranda rights. This was established through some court cases, but it's to make sure that those people who are accused know what they can and cannot do, meaning that if they say anything without the presence of their attorney, it might actually incriminate them more. So, moving on. Responsibility of criminal conducts of others. Persons who aid in committing a crime is also guilty of that crime. So individuals who might act as a lookout certainly could be tried within the court and found guilty and basically ending up having to serve time. One who plans the crime or otherwise intentionally helps is guilty of the same crime. So you could be an individual who plans a robbery, but yet you're not the one who partakes in that. If found guilty, you could go to jail, serve time for helping plan that. Officers of a corporation can be held criminally liable for the actions of their managers or other workers. That's vicarious criminal liability. So, it's always best to kind of be policing yourself, especially within the business world. Defenses to criminal charges, states must prove that the defendant is guilty beyond a reasonable doubt, and that's kind of the primary duty of the prosecution is to establish this case. A lot of times it takes maybe for a felony, roughly a year to kind of get that all organized for a date before the courts. Defense is the legal position that allows a defendant, the person who's been accused, to escape their criminal liability. And there are basically two types of defense. There's a procedural defense and a substantive defense. And we're going to kind of break this down a little bit. When we talk about procedural defense, this is where we have problems based on the way the evidence has been obtained or the way that the accused is arrested. So if a defendant confessed to a crime, they might assert that they confessed only because they felt like they were threatened by the police. It could also get into issues about how evidence was handled. So if there's any questions about maybe a crime lab mishandling DNA, that would be part of a procedural defense. Substantive is basically trying to disprove, justify, or excuse the alleged crime. In other words, this comes from things like using objections in courts, discrediting the facts that state sought to establish. This is hard to do, but if you have a good defense attorney, they're going to be using this type of defense to make sure that as a jury is listening to the case, that there might be some doubt about maybe how the state or the prosecution is building their case. There is also self-defense, which is is the use of force that appears to be reasonably necessary to the victim to prevent death or serious bodily harm, kidnapping, rape. So an individual might shoot at a robber and end up wounding or killing that individual. The question is, were they in the right to fire upon somebody who was possibly breaking into their property to steal something or to harm someone? That's where the self-defense would come in. When we talk about criminal insanity, this is a criminal insanity issue is merely a legal issue. In the world of psychology, we don't necessarily refer to somebody as insane. Usually we use terms like mentally ill and such, but this generally exists when the accused doesn't know the difference between right and wrong. And you have to prove that. So if you're going to prove that someone is not capable of knowing that difference, you're probably going to have to use some testing to prove whether or not a person is mentally ill. And that takes a little bit of time to do so. Immunity, this is freedom from prosecution even when one has committed a crime is charged. Great examples of this when we talk about issues of public officials. If, let's say, a lawmaker is on their way to Lincoln to work at the unicameral or to do their duty as a state senator, and they're speeding to get to work, they might be able to prove that they were on their way to work and that excessive speed was necessary to perform the duties that are vested in them. And so you might be able to get an immunity charge, which, by the way, this whole scenario that I'm giving you has happened in our state. The government may grant immunity to a reluctant witness to remove the privilege against self-incrimination. In other words, if somebody testifies against someone else, they might be given immunity for that testimony. If you refuse to give the testimony once you've been granted immunity, you can be found in contempt of court, and that is punishable by going to prison. So certainly if you make that as an agreement, you have to follow through with it. Punishments for crime. Punishment is any penalty provided by law and imposed by a court. It's not to remedy a wrong, but to discipline the wrongdoer, and should basically determine similar behavior. It kind of sets in a precedent, so to speak. Plea bargaining, this is when an accused agrees to plead guilty to a lesser serious crime in exchange for having the serious charge dropped. So if a person admits to committing a murder rather than being given the death penalty, if they plea bargain that down, they might be given maybe a less serious charge like life in prison, or they might be given life in prison with possibility of parole or such. Along with that, you have the accused. This individual gives up the right to a public trial to avoid a greater crime. Thank you very much.